There's a funeral today for a man shot dead July 19 in a Florida parking lot. The shooting is on video. Everybody knows who did it. And the culprit has not been charged because of the Florida Stand Your Ground law. It's the same one much discussed in the context of the George Zimmerman killing of Trayvon Martin. And now federal lawmakers are calling the DOJ to investigate. So how did we get here? After finishing her nursing shift, Brittany Jacobs and her boyfriend, Marquise McGlockton, wanted to grab some snacks and drinks. So they took their car full of kids, all under the age of 6, to this Circle A convenience store. They parked in the handicapped spot despite the fact that none of the car's inhabitants is disabled. McGlockton and their 5-year-old then went inside. Also in the lot, Michael Draka, a regular at the Circle A whose pet peeve was able-bodied people taking that reserved spot. After inspecting their car for a handicap permit and finding none, Draka began to lecture Jacobs. It grew heated. McGlockton noticed, came out of the store, confronted the man threatening his girlfriend and kids, and violently shoved him to the ground. Draka immediately takes out a gun and shoots him. After the sheriff declined to charge Draka, there were public protests and calls for the state's attorney to do otherwise. Florida Senator Bill Nelson sent this letter to Jeff Sessions asking the DOJ to investigate the case, with signatures from Cory Booker, Kamala Harris, and Representatives Charlie Crist and Alcee Hastings. Joining me now to discuss both sides of this issue, Benjamin Crump, the attorney who's representing Brittany Jacobs, who famously represented Trayvon Martin's family, and veteran criminal defense attorney Mark O'Mara, who defended George Zimmerman. Benjamin Crump, I want to begin with you. The sheriff said that the shooter felt that having been slammed to the ground, he was going to be slammed again. Is that the right question?
I don't think so, Michael. You can watch the video and it's clear. When he pulls that gun out, and we have to remember, he's the initial aggressor. This is a strange man who approaches a mother in the car with her 2 toddlers in the back seat. And now just imagine that for a second, how fearful that is. But after Marquise McGlockton comes out to defend his family and defend his property, if anybody should have the right to stand your ground, it is him. And when he pushes him back and he falls, he pulls the gun out. Watch the video. Marquise McGlockton takes 4 steps back, 4 seconds elapse. He is not in intimate fear. There is no objective threat. There is no justification for him shooting Marquise McGlockton in front of his infant children. I mean, his 5-year-old son reaches out for his father, and his father falls at his foot. And that is the last memory that child will have for the rest of his life of his father living.
The local sheriff, who, by the way, is also an attorney, had this to say a week ago Friday. Roll the tape.
What's relevant is not whether this guy's a good guy, nice guy, or whether he's a jerk, or whether he's a thorn in people's sides, and what he's done, whether it's 3 weeks ago, 3 months ago, or 3 years ago. What's relevant, and the only thing that we can look at here, is was he in fear of further bodily harm because of what Marquise McGlockton did, and was he in an ability and have the capability to carry it out? And the answer is yes.
Benjamin, the question that I ask as I watch that and evaluate the tape myself, is the sheriff's analysis incorrect, or is the law at fault? I'm not comfortable with the outcome of this case, I should say right up front so that my perspective is known. But am I to blame the law or the way in which it's being applied?
Well, I think the sheriff is incorrect. The state attorney, Bernie McCabe, should know that there's enough evidence to charge this killer with cold-blooded murder. And that's troubling for many in communities of color, that you can pick a confrontation, you can be the initial aggressor, you kill the unarmed black person, and then you say, oh, it was self-defense, I was standing my ground, and you get to go home and sleep in your bed at night. We think the law is a bad law that encourages people to take the law into their own hands. It's a license to kill black people and people of color, because many times when black people make their stand your ground argument, it's behind the bars of a jail cell. But white people make their stand your ground arguments a week later after they've been sleeping in their bed comfortably. So the law's been applied racially and calculated, we believe, and it's a terrible law that Florida needs to address. They were the leader for stand your ground. Hopefully they can be the leader in gun responsibility laws. We have all these laws for gun rights in the state of Florida, but we have very little laws about gun responsibility, if any.
Benjamin Crump, thank you so much for being here. Let me shift to Mark O'Mara and get Mark's analysis of this issue. Mark, was this a case of retribution or self-defense?
Well, you know, the way Ben said it is a good analysis of it. The sheriff had a problem with the stand your ground law because the sheriff could, in fact, be held liable if he arrests without good reason. So to answer the question, when you look at that tape, when you look closely at it, Mr. McLaughlin I disagree with Ben. McLaughlin was the initial aggressor in that he started the physical confrontation. Having said that, he also backed off after that. And I don't think that the shooter at that point gets to shoot, as you say, and as I said, in retribution. I have a tough time believing that even though he was on the ground, that he was in reasonable fear of imminent great bodily injury. Everything else aside, we do need to look at it from Drejka's perspective. Are you in reasonable fear at that moment of ongoing imminent great bodily harm? And quite honestly, I don't think the tape shows it, even presuming the way a person looks, reacts, and interprets things when they're in the middle of a physical confrontation.
In other words, Mark, if we could Zapruder the tape, we have to stop right at that image where he's on the ground, the man who has shoved him is towering over him, and the question is, what's in his head, and is what's in his head a reasonable fear of imminent great bodily harm? Right there, boom, right there is the question, right?
That's absolutely correct. The only analysis I would add to it is we do need to look at it, as the statute requires, from Drejka's perspective, what he's going through. And I will tell you, there's things that he's going through that we don't see on the tape. You get thrown to the ground, you have a dump of adrenaline into your body. We know from cops telling us you get tunnel vision. You don't hear things the way, you don't interpret things the way. So sounding like a criminal defense attorney for a moment, Drejka is in a position where his perception of what's happening is also skewed because of what he's going through. But when you look at the tape, McLaughlin had backed away. There's a distance. He's not towering over him. And the idea of taking out the gun, pointing it, I'm almost okay with that. But the idea of center of mass shooting and killing a man over a push that is now ended, I don't see the justification.
Hey, Mark, I think Benjamin is right in saying that when the gun comes out, that the decedent appears to take a few steps back and probably a few seconds, maybe a split second, tick off the clock. Is it fair to say, oh, you were okay to pull the gun, but not to fire the trigger?
Yes, I think the answer to that is yes. And let's not forget that Florida a couple of years ago tried to pass what we called a warning shot.
He definitely, look at
statute.
that. By the way, he just backed up like 4 steps. I mean, if you watch it again, pardon my interruption, but we can all see this.
He absolutely did. And again, Florida tried to pass, almost did pass a warning shot statute that would have said you're allowed to take out the gun. You're even allowed to shoot it to let the person know I'm armed and I will use it. That's the theory behind it. But the idea with a 2, 3, 4 step backing up and a 2, 3, 4 second delay, I think that if you're going to exercise your Second Amendment rights, and we have them, we will always have them, that you have to do it responsibly. And here's the problem. Someone like Drejka, who used their weapon, in my opinion, unreasonably, really affects the rest of us in our ability to properly utilize our Second Amendment rights because he used it improperly.
That's right.
And now the focus is again on that.
Great observation. Thank you for being here, Mark. I appreciate it.
Thank you.
What are your thoughts? Tweet me at Smercondish. Go to my Facebook page. I will read some responses throughout the course of the program. This, I think, comes from Facebook. I'm a supporter of the Second Amendment and concealed carry. This, however, was murder. This jackass was looking for a fight. Like you said, a lot of blame to go around. Everybody was wrong, but illegal parking shouldn't be a death sentence. And Guy, Mark O'Mara just made that point, right? That this guy, in this instance, frankly, jeopardizes Second Amendment rights for a lot of other Americans because of the way that he acted. Yeah, they shouldn't have parked in the handicap spot. The guy who came out shouldn't have shoved him. But those are minor transgressions, in my opinion, in comparison to the guy who's been shoved, pulls out a gun, and responds with deadly force.